He's a nationally recognized expert on constitutional law. His scholarship has been cited and quoted in landmark Supreme Court cases, including opinions on the Second Amendment and on corporate political speech rights. And his 2011 book, Gunfight, The Battle Over the Right to Bear Arms in America, has received national acclaim. He's a graduate of Georgetown and earned his law degree from NYU. Then you'll hear from Beth Parker, who's Chief Legal Counsel for Planned Parenthood Affiliates of California. Prior to joining Planned Parenthood, Beth was a litigation partner at Arnold & Porter in San Francisco. She received her law degree from Harvard and her undergraduate degree from Yale. I'm going to take a few minutes to talk about the case, but I wanted to note at the outset that you can type in questions during the webinar, and I'll be able to see those questions, and we'll leave time at the end after the speakers speak about the case to address those questions. And also the webinar is being recorded, so eventually we'll have access to the recording. So I'm just going to start by setting up the background for the Supreme Court case, Whole Woman's Health. The case involves Texas's TRAP laws. We use the term TRAP to refer to targeted regulation of abortion providers. In other words, laws that are only applied to those who provide abortion and not to other types of medical providers or other types of procedures. The laws at issue in the case involve the admitting privileges law from Texas. That's a law that doctors who provide abortions need to obtain admitting privileges at a local hospital. And another law requiring clinics to be essentially mini hospitals. It requires health centers that provide abortions to comply with requirements for ambulatory surgical centers. And if these laws are in effect, it would leave a handful of clinics in the entire state of Texas and leave many women hundreds of miles from any provider. So the case essentially asks the court to consider the meaning of Planned Parenthood of Southeastern Pennsylvania versus Casey, the court's 1992 decision that affirmed the abortion right first articulated in 1973 in Roe versus Wade, but did so within a new framework that prohibits abortion regulations that place a, quote, undue burden on a woman's right. So part of what's being asked of the court is what exactly does Casey's undue burden standard mean? To vindicate the interest in protecting unborn life, the state can seek to dissuade a woman from having an abortion. And so in Casey, for instance, we saw that informed consent and waiting period laws were upheld. But the state can't hinder a woman from having an abortion. Much of the abortion-related regulations that we've seen since Roe have been of this kind. Mandatory counseling laws, waiting periods, bans on certain late-term abortion procedures. These are laws that are justified by the state's interest in protecting unborn life. But those aren't the kind of laws that are issue in this case that the court heard yesterday. Instead, we're dealing with laws justified as protecting women's health rather than protecting unborn life. And in Casey, the court actually separately treated health-related regulations when it stated, quote, unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion impose an undue burden on that right. So it seems that a health-related regulation must actually serve its purported purpose, protecting pregnant women's health. Otherwise, it might be an unnecessary health regulation, and its purpose or effect might be to present a substantial obstacle to a woman seeking an abortion. And so if it's not serving a health-related purpose, then it's probably simply an effort to protect unborn life by another means, and those means aren't simply persuading, but instead are hindering. And Adam will talk more about the justice's interest in this question of purpose, but when these laws actually were passed, we have some indications of how abortion rights opponents were thinking about it. Texas Governor Rick Perry had declared, quote, the ideal world is one without abortion. Until then, we will continue to pass laws to ensure that they are as rare as possible. And the Texas Lieutenant Governor tweeted after the law's passage a map showing the abortion clinics that would have to close in Texas with the accompanying statement, "We fought to pass SB 5 through the Senate last night, and this is why." Seemingly upon the advice of legal counsel, he clarified in a tweet, quote, "I am unapologetically pro-life and a strong supporter of protecting women's health. SB 5 does both," close quote. The laws, in other words, must be justified on grounds of women's health and not on grounds of obstructing women's access to abortion. Yet in considering the constitutionality of the laws, the Fifth Circuit Court of Appeals simply deferred to the state. In fact, it applied a rational basis test, the lowest level of constitutional review, as if the abortion right is not a constitutionally protected fundamental right, and as if Roe and Casey do not stand for heightened scrutiny for that right. Instead, the Fifth Circuit reasoned that the state can rely on, quote, "rational speculation unsupported by evidence or empirical data." But that's not Casey, and other courts that have weighed in similar health-related regulations or trap laws, like the Seventh Circuit and the Ninth Circuit, have both found that those laws pose an undue burden under the Casey standard, and that Casey is not a rational basis standard. Casey was a compromise. It was an opinion that was drafted primarily by three justices, Justices Souter, O'Connor, and Kennedy, and had dissenting opinions and concurring and dissenting opinions in which the conservative dissenters wanted rational basis review and lost. And instead, Casey retained some form of heightened scrutiny for laws regulating the right to abortion and specifically instructs courts on how to think about health-related regulations. Now, I said the three justices who authored Casey, which retained the right in Roe, were Kennedy, Souter, and O'Connor. And Kennedy is the only justice left from that Casey majority that affirmed Roe on the court. And so, of course, for multiple reasons, we're all looking to Justice Kennedy on these questions. But here in particular, the Fifth Circuit's interpretation of Casey certainly seems to be at odds with what Justice Kennedy was communicating in the jointly authored opinion in Casey. And now I'm going to turn it over to Adam to tell us more about how Justice Kennedy and the other justices were thinking about the issues yesterday. Adam?
Well, thank you very much, Doug. I really appreciate it. And thank you all for listening in on our webinar. I was at the Supreme Court yesterday. It's always a thrill to attend oral argument in the Supreme Court. It's really a special thing, and I recommend everyone to get a chance to do it once in your life at least. And it's especially the case when there's a big, high-profile issue. There's a lot of energy surrounding it. I remember yesterday when I was walking to the court, about a block away, I could hear the sounds of protesters. And I thought to myself, of course, the pro-life forces are out in force in front of the Supreme Court, as one might expect on a day when they're deciding a big abortion case. When I got to the actual front of the court and the famous marble staircase, I was surprised to find that the sounds I heard weren't coming from pro-life advocates, but predominantly from women's rights advocates, and that the protesters in front of the Supreme Court were overwhelmingly women's rights advocates, not pro-life advocates. So that was an interesting surprise. Once inside, the courtroom was unusual. Justice Scalia was not there, and instead, in his place, there was simply a black robe laying over his chair, which is part of the Supreme Court ceremony when a justice dies while on the bench. And that was very odd. Scalia had really defined oral argument with his biting and insightful comments and questions that often put advocates at a great disadvantage. But he was not there. His absence was not merely atmospheric, though. Justice Scalia was a reliable vote to uphold restrictions on abortion. So his absence changes the dynamics of the court's decision in this case. With 8 justices, there's a variety of different ways the court could go. The court could split 4-4. In that event, there will be no opinions written in the case, most likely. The norm on the Supreme Court is if a case is split 4-4, they just issue a one-line order saying that the court was split and the lower court ruling is upheld. That would be a great victory for pro-life advocates in this instance. Conservatives really need only 4 votes to win this case, because a tie means the lower court, which upheld these restrictions on abortion, would be upheld. Pro-choice advocates, however, still likely need 5 votes to overturn the lower court. A split decision does not help them. They need to get 5 votes. The first 30 minutes of the argument were almost entirely taken up by questions about the evidence in the record, about whether the clinics that closed in Texas closed because of this law. So as you may know, 22 of the 41 clinics have closed. It's expected that the number of clinics remaining after both of the provisions, the admitting privileges and the what's known as the ASC, the ambulatory surgical center requirements, once they fully go into effect, it's expected that there will only be 8 of the 41 left. And in what seemed, at least to my mind, like a scene out of Alice in Wonderland, there was extensive questioning from the bench, especially from Justice Alito, about whether the closure of these clinics had anything at all to do with these laws. Justice Alito suggested over and over again that there was nothing in the record of this case to support the claim of causation, that he suggested that clinics close all the time, and they close everywhere, and not just because of this law, and they could have closed because of other laws or because there's not enough business, and that the record was devoid of evidence to suggest that they closed because of the law. Now, the advocate for whole women's health kept reminding Justice Alito that the day the admitting privileges provision went into, or the day the ASC requirement went into effect, 11 clinics closed on that very day. Seems like a pretty good indication of the relationship between the law, its extensive requirements for retrofitting, which go so far as to detail what kind of water fountains you can have, the angle of the water fountains, the width of hallways, the size of waiting rooms, et cetera, et cetera. Justice Kagan responded to Justice Alito by saying, don't we have a perfect natural experiment here? 11 clinics closed the day the ASC requirement went into effect. Then a lower court decided to enjoin those provisions to stop them from being effective a few weeks later, and the clinics immediately reopened. And she suggested that she was suggesting that what Justice Alito's question was really silly at the end of the day. And there was, like I say, this Alice in Wonderland feeling that we were debating things that everyone knows to already be true, such as the fact that these clinics are closing in response to this law. There was a significant question, especially from the Chief Justice, about whether the evidence in the record supported the claim that these laws pose a substantial burden or a substantial obstacle to women accessing abortion. While indeed many of the clinics will have closed, the Chief Justice suggested that it's possible that the remaining clinics, the ones that stay open, could handle all of the abortions in Texas, in which case the implication was there wouldn't be an undue burden. Currently, Texas has about 70,000 abortions each year, and the Chief Justice suggested that he was unhappy that the record did not provide with clarity whether the 8 remaining clinics could handle 70,000 abortions in Texas each year. Left out of the Chief Justice's concern, however, was the effect on women, especially women who have to travel hundreds of miles to get to those remaining 8 clinics. It was almost as if the distance that they had to travel just didn't matter, as long as if they were to travel, they could get an abortion. there was considerable discussion among the justices and the advocates about the nature of the undue burden test from Casey. Doug's already given you an overview of that undue burden test. And interestingly enough, it seemed that the Chief Justice thought that the undue burden test was only a matter of impact. So as Doug said earlier, Casey says if a law has the purpose or effect of imposing a substantial obstacle to women's access, then it would be an undue burden. But the Chief Justice thought that the only thing that should matter was the impact of the law, and not the impact of the law on clinics, i.e. do they close or do they not close, but the impact of the law on women. And he thought that if women could still obtain abortion, then it was not an undue burden. The Chief Justice was challenged, obviously indirectly the way the court works, but nonetheless challenged quite clearly by 4 other justices on the Supreme Court. Justices Ruth Bader Ginsburg, Justice Sotomayor, Justice Elena Kagan, and Justice Stephen Breyer. They all challenged the Chief Justice and focused like a laser beam on the lack of a substantial health justification for the law. They were interested, in other words, on the intent of the law. Their suggestion was that if there was not a valid health justification for the law, then the law did have the purpose of limiting abortion, limiting access to abortion for women. And so the intent and the purpose of the law would matter. Justice Breyer asked a very telling question at one point to the Solicitor General for the state of Texas. Justice Breyer said, can you show me anywhere an instance of a woman who was harmed because a state did not have the admitting privileges and ambulatory surgical center requirements? He said, as far as he can tell, and as far as the lower courts have been able to tell, there are no such women. Abortion clinics in Texas, even if the doctors do not have admitting privileges at local hospitals, have traditionally always had working arrangements with local hospitals so that if someone does suffer complications, they can immediately be transferred and admitted into the hospital without any difficulty. And of course, as you probably already know, that if someone is facing a medical emergency, they can go to any hospital in America, and that hospital has to treat them. So even without admitting privileges to the local hospital, any woman suffering from complications relating to her abortion can go into an emergency room, and that emergency room will be required to treat her. So Justice Breyer was suggesting that there was no health justification behind the law. There was no one who was actually being harmed by the old status quo. And so the idea that women need these protections was absurd. In a series of related questions, we saw a very impressive performance by the 3 female justices on the court. And I will say that being in the courtroom and seeing a court that was nearly evenly divided between men and women, 5-3 men, but nearly evenly divided, and to see 3 women dealing with this issue in a very assertive and very direct and intelligent way was a real challenge to the Chief Justice and to patriarchy itself, I thought. It was wonderful to see. They were incredibly strong, and Justice Ginsburg led the way. She continually asserted that the law here was overbroad. She pointed out, for instance, that the law requires someone who is receiving a medication abortion, as compared to a surgical abortion, is still required to go to a clinic that has an ambulatory surgical center within 30 miles of a hospital to take their pills. 2 pills that in other states women generally take at home. Texas said, well, we still think it's important to have these requirements of an ambulatory surgical center because complications could arise with a medication abortion too, and someone might need emergency surgery. Ruth Bader Ginsburg pointed out that complications from medication abortions don't happen on the spot. They happen often sometime later, and they'll arise for women mostly at home after they've returned home from the clinic. So having this ambulatory surgical center did not further the goals of women's health at all. The women wouldn't even use them, at least to the extent there's a medication abortion. Justices Sonia Sotomayor and Elena Kagan repeatedly pointed out in the argument how many other outpatient procedures there are that have far greater risk of complications, but yet do not require those who are administering those outpatient procedures to have admitting privileges at a local hospital, and that the clinics that provide those outpatient procedures are not required to meet the standards of an ambulatory surgical center. They pointed out that things like colonoscopies have 28 times the rate of complication than abortion. And yet colonoscopies can be done in a clinic by a doctor without admitting privileges and without an ambulatory surgical center. Liposuction, same thing, and has even greater risk of complication than colonoscopy. Justice Ginsburg even pointed out at one point that if Texas gets its way and women don't have abortions, that childbirth itself has a higher risk of complication than either a surgical or a medication abortion. The thrust of their arguments was clear, that this law was about restricting abortion, not about preserving or promoting the health of medical patients. Texas doesn't seem to be nearly as interested in the health of medical patients who go through colonoscopies, liposuction, or other outpatient procedures. The big question, of course, coming away from the oral argument is what should we expect? What kind of ruling will come out of the court? Of course, those of you who follow the Supreme Court know that it's very unreliable to rely on oral argument and make a strong inference about how the court will rule. But nonetheless, we can try to gather some sense of the direction that the court might go from the questions that they asked. There were three justices seemingly prepared to uphold the restrictions in their entirety: Chief Justice Roberts, Justice Alito, and presumably, although he was silent, Justice Thomas. Justice Thomas's views are not unclear in this area. He's been on the Supreme Court for 25 years and has voted to uphold every single restriction on abortion to come before him. There were four justices clearly prepared to overturn the restrictions. Justices Ginsburg, Sotomayor, Kagan, and Breyer were all very clearly unhappy that these provisions were still on the books without any health justification. And that brings us to Justice Kennedy. As usual in the Supreme Court, a hot-button case comes down to his vote. There's a reason Time magazine put him on the cover not too long ago with the label, "The Most Powerful Man in America." And that's certainly the case when it comes to women's right to choose. Justice Kennedy did not show his hand clearly. He sometimes does that and makes very clear to advocates how he's going to rule, but this time he did not. At one point, he did suggest that the law may be undermining women's health by reducing medication abortions and increasing surgical abortions. He was also concerned that the record in the case was incomplete. Although he was not that interested in Justice Alito's question about whether there are facts in the record to show that these clinics that closed did so because of this law, he did seem to be interested in the Chief Justice's question, which is whether there are facts to show whether the remaining clinics have the capacity to handle the demand for abortion in Texas. Again, it wasn't crystal clear, but he did seem to have be leaning in favor of either overturning the provisions or remanding the case to the lower court for more fact-finding about the effect of the law and the capacity of the remaining clinics. A remand would be a small victory for whole women's health, Obviously, Whole Woman's Health wants to have the law declared unconstitutional here and now. But a remand would send, while leaving the law on the books, would send the case back to the lower court for more hearings. And the questions that are likely to be asked at those hearings may weigh in favor of Whole Woman's Health. Indeed, the case would return to the same district court judge that ruled these provisions were unconstitutional in the earlier round of this case. Of course, there would be an appeal of whatever the district court does, and that appeal we would expect to eventually make its way back to the United States Supreme Court. Which really brings us, in a way, back to Justice Scalia and his vacancy on the court. If Scalia's successor is one who believes that women do have a fundamental right to choose abortion, then the provisions in Texas would likely fall. The good news for pro-choice advocates is that if Scalia's successor does believe that women have that right, Justice Kennedy, who has a history of wavering on abortion, being an important vote in favor of upholding the core holding of Roe versus Wade in the Casey case, but also being the author of the Supreme Court opinion upholding restrictions on late-term or so-called partial birth abortion. Kennedy is a fence straddler on issues of women's choice. If Scalia's successor believes that women have the fundamental right to choose, then Kennedy would no longer, his vote wouldn't matter that much. There would be 5 justices to overturn these restrictions and presumably provide more protection for the right to choose than we've seen from the Supreme Court over the last 20 to 25 years. Thank you.
Thanks, Adam, for that. And now we're going to hear from Beth. And just again, a reminder, you can, if you have questions, type them in to the webinar, and we'll be able to get to those questions eventually. Thank you.
Thank you, Adam, and that was fascinating. I want to now provide a picture of what's actually at stake on the ground in this case, why this is one of the most significant abortion cases in decades, and what could happen if these restrictions are upheld. But first I want to go back and describe what has happened since the last time the Supreme Court considered abortion. In 2007, as Adam indicated, Justice Kennedy decided on behalf of the Supreme Court and upheld the federal ban on so-called partial birth abortions in the Gonzalez versus Carhart decision. And in that decision, the court indicated its willingness to reverse 3 decades of its own jurisprudence and give states unfettered discretion to pass abortion restrictions. And it did this in 2 ways. First, before that case, the law basically said that if there was a disagreement in the medical community as to whether a health exception was necessary for an abortion restriction, courts were to err on the side of including a health exception. To do otherwise would grievously injure a woman's health. The Supreme Court reversed course in Gonzalez and said if there was a division of medical opinion, Congress or the legislature gets to make that decision, and the act can survive a constitutional attack. And by doing this, the court paved the way for legislatures to pass restrictions on abortion where there were no exceptions, even if the woman's health or life was in danger. And the language the court used had broad implications. I quote, "The court has given state and federal legislatures wide discretion to pass legislation in areas where there is medical and scientific uncertainty." In addition, the court made clear that while it would not undo the right to have an abortion, it had no qualms about making access to exercise that right extremely difficult. Justice Kennedy said, quote, "The fact that a law which serves a valid purpose, one designed to strike at the right itself, has the incidental effect of making it more difficult or more expensive to procure an abortion cannot be enough to invalidate it," end quote. The conservative right seized upon this language to pass increasingly restrictive legislation. Next slide. By 2015, state legislatures had passed 288 abortion restrictions, To put this in perspective, more restrictions were passed between 2011 and 2015 than the entire preceding decade. And not just one restriction was passed in any state, but many. 27 states now have at least 4 types of abortion restrictions. Louisiana has 10. And as a consequence, the number of women who now live in states either hostile or extremely hostile to abortion is 59%. Next slide. In addition, the number of healthcare facilities where women can access abortion is shrinking at an alarming rate. Unlike many other medical procedures, most abortions are performed at standalone community clinics or health centers, which makes them particularly vulnerable to targeted restrictions. Just this week, Bloomberg Business reported that at no time since before 1973, when the U.S. Supreme Court legalized abortion, has a woman's ability to terminate a pregnancy been more dependent on her zip code or financial resources to travel. And these restrictions fall into 4 primary categories. They restrict who can perform the procedure, where it can occur, what procedure can be used, when, as well as if and how the cost can be reimbursed. And they go far beyond the waiting periods and parental notifications or consent that we saw in the 80s and 90s. They now include targeted restrictions on abortion or trap laws, such as the 2 that Doug described at issue in this case, prohibitions on coverage of abortion in insurance plans, limitations on medication abortion, and bans on pre-viability abortions. Next slide. Now, many of these restrictions have been challenged and then enjoined under the existing Casey standards. For example, courts in Alabama, Mississippi, and North Dakota have stopped laws requiring admitting privileges from going into effect. The Oklahoma Supreme Court enjoined that state's prohibition on mifepristol to induct abortion and methotrexate to treat ectopic pregnancies. And the Ninth Circuit invalidated Arizona's 20-week ban on pre-viability abortion. But all of these successful challenges rely on existing Supreme Court precedent, which, as both Doug and Adam have described, is being attacked directly in the whole women's health case. So the stakes of this case cannot be overstated. A woman's fundamental right to access safe, legal abortion is before the court. And the consequences of this decision could well reverberate beyond Texas. Because if the court upholds these laws, it will mean that although abortion is legal, it is effectively banned for many women. And a woman's right to make personal medical decisions about her pregnancy depends in large part where she lives and how much money she has. So let's look at Texas, because those laws are highly instructive. Next slide. Thank you. It paints a grim picture of what could become a reality nationwide if the court upholds these laws. If all these restrictions go into effect, the 5.4 million women of reproductive age in Texas will be left with only 8 health centers that provide safe, legal abortion in the entire state. And that's down from 41 in April of 2013 when these laws were passed. And the remaining health centers are all in the major metropolitan areas of eastern Texas. If these laws were implemented, 1 in 5 Texas women would be more than 150 miles from a facility. So this forces women to travel hundreds of miles, cross state lines, and wait weeks to get an abortion. And many women can't wait this long. The window is very short. And many other women cannot afford to take time off of school or work, arrange for childcare, and raise the funds for transportation and a hotel if they need to travel long distances just to access a safe and common procedure. And as a result, these restrictions impact poor women the most. In fact, research from the Texas Policy Evaluation Project recently found that at least 100,000 Texas women aged 18 to 49 have tried to end a pregnancy on their own without medical assistance since these laws passed. And the reasons they most commonly cite are not having the funds to travel to a clinic or pay for the procedure, or that their local clinic has closed. And some women are already forced to wait as long as 20 days, 4 weeks, to access safe legal abortion. And while abortion is an extremely safe procedure, it is safest earlier in pregnancy. Up to 9 weeks, medication can be used, and after that, a different medical procedure is required. And because later procedures take longer and are more invasive, these delays directly impact the health and safety of women who choose to terminate their pregnancy. Researchers even estimate that in Texas, these longer delays could double the percentage of abortions in the second trimester. And as I just indicated, this forces women to undergo a more invasive procedure, not because of medical reasons, but because of political ones. And depending on what the court decides and how, the impact could go far beyond Texas. Next slide. If the admitting privileges are upheld, for example, doctors would be forced to establish difficult-to-obtain relationships with local hospitals. These, in effect, give hospitals veto power over a health center's ability to offer this service, because many physicians can't get admitting privileges for reasons that have nothing to do with their credentials or their quality of care. So these laws are really another backdoor attempt to ban abortion by making it inaccessible. When this law was passed in Wisconsin, it resulted in closure of 1/2 the clinics in that state. In Texas, it prevented 1/3 of licensed providers from doing their jobs. In Alabama, it forced women to travel over 700 miles round trip to access reproductive health care. And there's absolutely no evidence that admitting privileges are needed for abortion care. According to the Center for Disease Control and Prevention, abortion is more than 99% safe. As both the AMA and the American College of Obstetricians and Gynecologists have said, there is no medical basis to require abortion providers to have local hospital admitting privileges. And courts today have blocked these requirements, similar to those in Texas, in Alabama, Louisiana, Oklahoma, Mississippi, and Wisconsin. So if the Supreme Court upheld the Texas laws, presumably all of these laws could go into effect. If the laws requiring the clinics meet the standards for ambulatory surgical centers, the other Texas restriction, if those were upheld, health centers would be required to pay for hospital-grade facilities. These regulations typically impact buildings, equipment, and staff, so they have huge economic implications. And as a result, it is highly likely centers will be forced to cease performing abortion or close, and no new centers will open in their stead. And as with admitting privileges, these regulations are completely unnecessary. Medication abortion is just taking 2 pills. Even surgical abortion, which takes about 5 minutes, is far safer than many other procedures, such as colonoscopies or liposuction, as Adam explained, that are routinely done in outpatient clinics. And for these reasons in California, we were successful 2 years ago eliminating all of the antiquated requirements imposed on primary care clinics that offer abortion. And nobody during our legislative hearings cited any evidence that they would have any adverse, by their elimination would have any adverse impact on women's health. Finally, if the court were to uphold the Texas laws with very expansive language, essentially deferring to legislatures, then many of the laws that have currently been passed but enjoined in all different areas, not just admitting privileges and ambulatory surgical center requirements, all of these could go into effect. And legislatures would feel further emboldened to pass more and more restrictive legislation. This would result in large parts of our country, basically all states except for the Northeast and the West Coast, having minimal or no access to abortion. And women would then be forced either to continue with an unwanted pregnancy, to travel long distances at great expense to access the procedure, or, as we have tragically just seen in Texas, resort to self-induction with the potentially severe health consequences that entails. What is really alarming about this scenario is that the public overwhelmingly disapproves of politicians' attempt to eliminate a woman's right to access safe legal abortion in the United States. 1 in 3 women in America will have an abortion during her reproductive lifetime, and no mother wants her daughter to have fewer rights than she did. A Vox poll released this week found that 65% of Americans believe these restrictions put an undue burden on women. 70% of Americans do not want to overturn Roe versus Wade. And this support crosses both party and demographic lines. 68% of millennials do not want to see Roe versus Wade reversed. Even 72% of Republicans believe abortion should be available. So whatever happens in whole women's health, and Adam described various scenarios, the fate of abortion in our country could rest in the hands of Justice Scalia's replacement. If the Republicans have their way and thwart President Obama's choice of Scalia's successor, it could well depend on the outcome of November's election. In the meantime, we at Planned Parenthood will continue to offer safe legal abortion wherever we can and fight hard to protect both that right and access to it. Thank you.
Thanks, Beth. That was devastating and helpful to get a sense of what the impact is on the ground. And before we start wrapping up, I just wanted to talk about another case before the court that also directly impacts women's access to reproductive health care. And again, something that will have a very real impact on women around the country. The court on March 23rd is going to hear argument in a case captioned Zubik versus Burwell. That's a case from the Third Circuit, but there's actually multiple cases that have been consolidated up at the court, including ones you might have heard of under Little Sisters of the Poor and Priests for Life, that involve the contraceptive coverage requirements in the Affordable Care Act. These contraceptive coverage requirements were at issue in the 2014 decision of the Supreme Court in Hobby Lobby, and this is in some ways a follow-up to that case and an even more potentially dangerous case. The question is whether the accommodation mechanisms used in implementing the Affordable Care Act's contraceptive coverage requirements violate the Federal Religious Freedom Restoration Act, RFRA, when applied to objecting religiously affiliated nonprofit organizations. So RFRA provides that the government can't impose a substantial burden on an individual's religious exercise unless doing so is the least restrictive means of furthering the government's compelling interest. And this is what we generally describe as strict scrutiny in the law, meaning the government has a very high burden in enforcing the law against the challenger. In Hobby Lobby, the court ruled 5-4 that closely held for-profit corporations, one, could actually assert claims under RFRA, and two, couldn't be forced to provide health insurance to their employees that covered contraceptives when those corporations were religiously opposed to the use of contraceptives. And in that case, the majority held that Hobby Lobby's religious exercise was substantially burdened by the contraceptive coverage requirements, and it then decided that assuming, and only assuming, it didn't actually find that the government has a compelling interest in women's health, that enforcement of the contraceptive coverage requirements against Hobby Lobby was not the least restrictive means of achieving that interest. In other words, the government had alternatives available to it. One of those alternatives was that the government could pay for the coverage itself, which of course we know is not a reasonably available or politically possible alternative. And the other alternative was an accommodation mechanism used for religiously affiliated nonprofits. So under the regulations that interpreted and applied to the contraceptive coverage requirements of the ACA, one of the accommodations provided was for religiously affiliated nonprofits with objections to contraceptive coverage. And they could submit a form, it's called the Form 700, to the federal government to make their objection known. And then the government would actually work with insurer and a third-party administrator to make sure the employees of the objecting nonprofit had access to contraceptive coverage without cost. So it takes the objecting employer out of the equation. But the majority in Hobby Lobby stressed that it wasn't deciding whether that mechanism posed any issues with regard to the mechanism of accommodation under RFRA. And now that question comes up because religious nonprofits have claimed that filling out the form violates their religious beliefs. And when the government said you don't have to fill out the form and instead you can just notify us, they said that violates their beliefs too. So the claim is this: filling out the form or providing notice of a religious objection to the government in order to get an accommodation triggers the obligations of others to get access to contraceptive coverage to their employees, thereby making the claimants complicit in their employees' purportedly sinful conduct of using contraceptives. This complicity, they contend, is a substantial burden on their religious exercise. So I hope folks appreciate how breathtakingly broad this claim is. The idea is that notifying the government that you object to something in order to claim the religious accommodation is itself a substantial burden on your religious exercise. Again, all eyes are looking to Justice Kennedy. He was the decisive fifth vote in Hobby Lobby, and he wrote a separate concurrence. There's two potential ways for the court and Justice Kennedy to reject the RFRA claim here. The first is on substantial burden. Remember, the claimant is first supposed to show that their religious exercise is substantially burdened, and in Hobby Lobby, the claim was that providing insurance coverage that covers contraception makes the employer complicit in the employee's use of contraception, which the employer deems sinful. That itself seemed quite attenuated, but the court accepted that it was a substantial burden. The court said it's not for us to question. This new claim is even more attenuated. Notifying you of my objection so I don't have to provide coverage itself makes me complicit in some other party providing coverage to my employees. So do we just take the nonprofits at their word that this is a substantial burden? Hobby Lobby seems to suggest that we do, but the courts of appeals, except for the Eighth Circuit, have all said no and have resolved this question on the substantial burden inquiry, saying the religious nonprofits are not substantially burdened by this accommodation. If the court says there is a substantial burden, it could still say that the accommodation is the least restrictive means of achieving the government's compelling ends. So what would be another least restrictive means? The government paying for it itself. This gives rise to that question of whether we're actually talking about a reasonably available alternative. It's important to note that in Hobby Lobby, Justice Kennedy, in his concurrence, stressed, one, that the government has a compelling interest in making sure women have access to contraception, and two, that Hobby Lobby should be accommodated because he believed that the government could do so without infringing the rights of Hobby Lobby's employees. In other words, he said that the women would still get access to contraceptive coverage. This seemed to be the cost of securing Justice Kennedy's vote in that case. Justice Alito stressed in the majority opinion that the cost of accommodation would be, quote, precisely zero. That has not turned out to be true in practice. Hobby Lobby employees, many of whom still don't have access to contraception, would beg to differ with the court. But if Justice Kennedy is clearly worried about the harm to third parties, here the female employees of the religiously affiliated nonprofits, it seems like this is a case in which he would want to limit religious accommodation because such harms are imminent. The result of accommodation here would be that women have to go without contraceptive coverage through insurance and must get it themselves, pay for it themselves. And in fact, the claimants at times in their briefs at the court concede that point. So it'll be important at oral argument on March 23rd to look to see how Justice Kennedy is thinking about the harm to the female employees of these nonprofits, and also to see how the justices probe the lawyers for the claimants as to how those women would otherwise be getting access to contraceptive coverage. It doesn't seem like it's enough to say that the government can create a new program to do so. And that would be a grounds on which we can see the court reject these kinds of claims and then limit the damage that was done in Hobby Lobby, at least in this circumstance. So I'm going to stop there, and that leaves us a few minutes for questions, so folks can write in their questions, and we'll direct them to the speakers. We have one question here. Adam, your discussion of the questions at oral argument highlight how ambiguous the undue burden test remains. One of the arguments not discussed yet is the availability of abortions in New Mexico. This has often been discussed as showing why the reasons underlying the law are disingenuous. But assuming that a state has genuine reasons for trap laws, the argument suggests that if women can obtain abortions in neighboring states, then the laws may not constitute an undue burden. To the extent this matters in the undue burden test, it sets up a race to put these laws in place faster than neighboring states. Has this type of state borders argument or race to the bottom concern been an issue in this case or similar trap law cases? And I know this New Mexico issue was raised at oral argument. Adam or Beth, you're both welcome to comment on this question.
I'm happy to weigh in. This is Adam. And yeah, it was a very interesting moment at oral argument where Justice Ginsburg asked the Texas Solicitor General about his argument that this law is not an undue burden for women in western Texas, even though there's not easily accessible clinics within Texas in western Texas. They had argued, well, women could easily go across the border into New Mexico and obtain abortion there. Justice Ginsburg pointed out that if that's the case, if that's their argument, well, then they don't really have a strong health justification for the admitting privileges and the ASC requirement, because New Mexico has neither of those. And if Texas really believes it's important that women in Texas receive the protections from those provisions, then sending them off to New Mexico doesn't further that goal at all. We're seeing increasing numbers of arguments, an increasing occurrence of these kinds of arguments. Well, if we're going to close all our clinics or most of our clinics in this state, but you can always go across the border and obtain an abortion. It is a very troublesome argument. I think it's used because they want to show that the laws do not actually pose an obstacle to women getting an abortion. However, it is an argument that would justify a state completely ignoring a constitutional right or burdening a constitutional right. We've seen this argument made in other areas, and in other areas it has generally not been accepted. For instance, in an area where I do a lot of my research dealing with gun control and gun policy, conservative judges have rejected the argument that the fact that you can't do something within one place but can go to a neighboring place and do it is not good enough. So, for instance, there was an issue out of a case out of Chicago where Chicago banned gun ranges in their town, in their city, and the city of Chicago said, well, yeah, it might be constitutionally permissible, constitutionally required to have access to gun ranges if you have a right to bear arms, but you don't have to do it in Chicago. You can go somewhere else and do it. And the court struck that down, saying you cannot limit constitutional rights because someone else allows them to exercise those rights to be exercised. So I don't think that's going to be a winning argument in the long run, but we're seeing it made increasingly by supporters of these trap laws to justify the restrictions within their own state.
I just wanted to
add one practical aspect to it, which is if you recall the map I showed at the beginning of my talk of where all these restrictions are occurring, there are vast parts of the country where there are already many, many restrictions. And in essence, if you say it's okay to cross the border, what you're going to end up in is it's okay to travel to California or the Northeast, which, of course, is a huge burden on many women and really inaccessible for most.
I wanted to point out on the Zubik versus Burwell case, that one of the folks on our call, Lori Sobel, who's the Senior Policy Analyst for Women's Health Policy at the Kaiser Family Foundation, has an issue brief on the Kaiser Family Foundation website, kff.org, on the Zubik case. And so for folks interested in learning more about that, you can visit the KFF website, Contraceptive Coverage at the Supreme Court, Zubik versus Burwell, Does the Law Accommodate or Burden Nonprofits' Religious Beliefs? If we don't have any other questions or comments from folks on the call, then we'll end the call at this point, just a few minutes shy of an hour. I want to thank Adam and Beth for providing their expertise and commentary on these really important issues. I want to thank Lauren Zhao from the Williams Institute for coordinating this call and making sure it all runs smoothly. And I want to thank all of you for joining us on the call as we wait to see what the Supreme Court does in this really critical case. Just a reminder that this call has been recorded, and so people will have available to them the recording. Beth, can we also make your PowerPoint available?
Absolutely.
Okay, and we will also find a way, so some folks are writing in asking that, to make the PowerPoint slides available after the call. We'll work with Lauren to handle that. Thanks everyone for participating, and thanks to our speakers, and thanks to Lauren. Take care.